Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a very important book which I found very helpful in my own practice. This book is called Commercial Property Litigation. It's now in a second edition. It's been edited by and written by two people, James Fieldsend and Paul McAndrews. The book is available as an e-book and it comes to us from Jordan Publishing Limited. Now, my wife Elizabeth and I looked at this book, had a discussion about it, and for our review we've given it the title Avoiding the Pitfalls of Property Litigation, a detailed reference and practical guide, now in a new edition. Now we'll have a look at the review in a minute. Let's have a look at the book first of all. There's a CD, by the way, with it, which is right at the back. Let's see, there's a CD there. That's the front. Nice picture of the City of London. Guess where that is. And then you've got the spine, and then you've got quite a lot of detail on the back. This book, as I say, is available as an e-book as well, and because it's dealing with litigation, there is a very useful CD right at the back. Again, you just run that in the normal way when you're putting it in your computer. Now, this is the index at the back, and it's done by using paragraph numbering, which we'll show you in a second or two. There's obviously practice directions and various other things, a lot of appendices at the back. Then we get into the body copy itself. Let me just show you. This is on forfeiture. There is the numbering, the paragraph numbering. You've actually got footnoting, not too much, you'll be pleased to hear. Obviously you've got quite a lot of appendices at the back, which we'll talk about in a minute. The actual appendices start, so just get to that point. It's not too far back in the volume itself. But you do need to find where there are no shaded box areas, unfortunately, to help you. But it's about the last little bit of the book has got the appendices in it. This is the front of the book here. And now we've got the front with the name. And there's a very tender dedication, which I will mention there, which I thought would be important for you to see. And then there's a preface to the second edition, which has been written by the two authors there. And then you've got the contents, quite detailed contents, starting with notices, running all the way through. You see a lot of detail there, which is actually consolidated by the very detailed index as well. See the chapter headings here, and you go running through service charges. Then chapter 13 is on to ADR right at the end, and then you've got the list of appendices, which you can see there and running over. And there are a lot of appendices, in fact 34 in total. You can see those there. It's very difficult in this short review to give you too much of an idea of what's in it, but you've got a lot of cases, huge number of cases, and then you've got, after the case law, you've got statutes listed, statutory instruments, and then there's just, after that, you go straight into chapter 1 on notices, and I'm going to mention a bit of that in a minute. Right on the back of the book, you've got a list of the main chapter headings, which is very helpful. So at a glance, you can see what it is that you may, if you're advising a client, it may be something you want specifically to look at. So that will tell you very quickly where it might be in the book. Now, this is what we say. This is definitely a book for busy practitioners working in property litigation, primarily in landlord and tenant matters, much of which will be, of course, the county courts these days, although there obviously is the High Court as well, because the jurisdictions have changed. It depends very much on factors concerning each matter. This is a subject, commercial property litigation, that seems straightforward but isn't, and practitioners need to be aware of the possible pitfalls. I'm sure we're aware of some of them, but this book actually brings together, I think, a very useful summary for us as to where we might be going when we have a particular problem. Because I've always found as a barrister that when I have a particular case, a brief to counsel comes in, I sometimes do need to look at these books to just refresh my memory as to where we are with what the problems are, because one can assume you know what this is all about, but actually it is useful to have this as a sort of check, safe mechanism, if you like, to assist, just refreshing your memory as to where you are. The book itself has been published by Jordan's. As I've said, there's a CD and it's an e-book as well, and it's now a second edition of what is a thorough and scholarly yet practical work which indicates it's already highly regarded and well established with the practitioner. It therefore functions as a reliable source of reference on just about every conceivable contingency that can or may ensue for landlords, tenants and any other parties involved in property disputes. Taking the prevention is better than cure stance, the emphasis in the book leans towards advising opposing parties to avoid litigation altogether if possible, or at least to reduce it before disagreements, misunderstandings or omissions actually turn into disputes. Wouldn't it be lovely if that was applied in a much wider spread over the whole of law? Unfortunately it isn't, because of the nature of what happens between disputing parties and so forth. The two expert authors here have established this cautionary note right at the beginning, pointing out that disputes and problems leading to litigation commonly arise where one party to a tenancy serves notice on the other and the counterparty challenges its validity. So begins the first chapter, which is appropriately on notices, followed by the chapter on invalidity of notices. So we're going straight in at the deep end, if you like. These chapters contain considerable new material, notably the decisions in recent break clause cases. The practitioner is made aware that mistakes or omissions in these and related areas can lead to costly litigation and are therefore to be avoided. Subsequent chapters deal with such areas as lease renewals, dilapidations and repairs, subletting, changes of use and alterations, surrender, forfeiture, recovery of possession, and of course much more. There's also a chapter on service charge recovery, a very important area. That's obviously dealing again with commercial premises, with a final chapter covering the expedient of alternative dispute resolution, often favoured by many people, but when they come to me quite often ADR has gone and we're now really into the main fight, and that's what I think a lot of practitioners are faced with. Further new material in the book for this second edition, for example, covers the construction of service charge clauses and the treatment of dilapidation claims. Quote, perhaps the greatest change, say the authors, has been the abolition of distress for rent, with the new law on the matter having come into effect in 2014 with commercial rent arrears recovery, that's CRAR, replacing the right to distrain. And I'll just say before I say anything else that this concept of the word distress and distrain are concepts that frankly the clients find difficult to understand as words. So I'm glad that we are now looking at a slightly easier way of explaining what it is, because distress can mean a lot of things to a lot of people. But I think at least we seem to be modernising the language a bit. Do see chapter 10 for further details of this important new development, of which all practitioners in commercial property I'm sure must already be aware. Not only is this a detailed work of reference, it's been logically organised with the busy practitioner in mind. First there's the almost minutely detailed table of contents, a lot of information there, you should be able to find things quite easily. Some 13 pages in length in fact, which does make things easier to look up. Then there's the index at the back, and you've got numbered paragraphs throughout, which is where you can link in quite quickly. There are no less than 34 appendices, which I've indicated, which provide carefully drafted precedents, which I think are helpful. That's really where the CD comes in. Obviously you've also got claim forms, notices and draft proceedings and orders, and that's why they're obviously accessible on the CD, so they can be tailored to individual requirements, and it does actually save quite a lot of time once you've mastered how to use the CD, which is not as difficult as it might seem, although I have had frankly some problems, and I'm sure others have as well, basically getting it up and running and then trying to sort of link the stuff in and then print it out. But once you get used to it, it's not too difficult. Also note the extensive tables of cases, statutes and statutory instruments, which again are extremely helpful. There obviously is quite a lot of modern material there. Let me conclude by saying ideally this book should be part of the professional library of every lawyer, property lawyer advising or acting in landlord and tenant matters, especially considering the thoroughness and eye for detail that this area of law requires. And the new second edition especially should be considered an essential purchase if that's the area you're involved in, either as a firm or a set of chambers doing real property. The publicity date is cited as at 2015. Let's just have a quick look at the book again. Hardback, as I say. There's the front, nice bit of Canary Wharf there. Spine, and then the back. And if you just open it up in the middle, you can see again, this is actually Landlord and Tenant Covenants Act 1995 covered there. You can see the paragraph numbering at the sides, and you can see the footnotes. And again, if we start looking at the appendices, you can see again here, this is one on recovery of possessions, of possession rather. I'll just show you where that starts, so you've got some idea of what it looks like. There we go. That's actually, chapter 12 before we get into the main area. That's lease or licenses, those issues. Then we go to things like the appendices themselves. Appendix 21. This is tenant's response to former landlord's notice. So there's a lot of information here which is quite useful for the specialist lawyer involved in this area. And just remind you again of the detail of the index at the back and the CD. Well, thank you to James Fieldsend and Paul McAndrews. I think you've done a really wonderful job to give us this book. It's a great help in this particular area of law. It's a good friend to us, if you like, when we're actually advising clients, and it's nice to have something that's up to date and as user friendly, and the CD does help with the precedents. So thank you to all concerned and to Jordan's for producing this new work. Bye bye.